My name is Chauhan. I am a lawyer in Richmond Hill for the last 40 years and have a number of videos that we have done. You might want to look them up on my website jchauhan.com. And today's subject is on the question of the purchase of assets and what happens when you buy assets of a business. So to discuss that, we have Roshni Vora, who has completed all the requirements except the call to the bar, and she'll be called to the bar very shortly. And she'll pose the questions and we'll attempt to answer those questions. So here is Roshni. And so what are the questions, Roshni, that you have on this issue?
All right, well, for starters, if I or anyone was interested in a particular business, how would I consider whether I should purchase the assets of the business or purchase the shares of the business?
There are many technical issues, Roshni, that do arise when you're buying the assets or shares, and including the issues of tax and including the issue of what do you do when you take over the shares. In a technical sense, you're taking over all the assets and the liabilities of the corporate entity that you're taking over by buying the shares. So it has the biggest problem in the share purchase is that you're assuming also the liabilities of the vendor when you take over the shares. So that is the reason why many people are more often concerned about the history of the organization, and may, in that situation, prefer to buy the assets, in which event what you're doing is taking over the physical tangible assets, the lease, and then you are not responsible for the liabilities of the vendor's company. So this is the main difference between the two types of the purchases, and there are of course different tax implications of each of these transactions. So that's the main consideration that you'd have to go through, and in which event you need an accountant and as well as a lawyer, and the lawyer coordinates the purchase and the accountant helps with respect to the tax aspect of the transaction.
All right, so say we are looking at the purchase of assets. What type of considerations should I be mindful of in entering such a transaction?
When you're buying the assets, you're looking at a number of issues that are important in terms of the legal issues actually. For example, when you're buying the assets, you're taking over separate, what I call tangible and sometimes intangible assets as well, such as a trademark. But because you have to reassemble each issue to keep the organization as a business going, you would have to deal with things like the lease of the property, because you have to assume it from the vendor and take it over in your hands as the new assignee of the lease. And therefore the lease is one of the issues that you have to think about. Then there is the Bulk Sales Act, in which you have to deal with the question of complying with the act, and that's required by the Bulk Sales Act as a law. You have to deal with the question of what inventory do you take over, HST, and the tax issue. These are some of the main issues that you would have to deal with.
All right, well, you touched upon the lease, and obviously if I'm looking into a business, it's occupying a certain premises. What considerations should I be mindful of with respect to the lease?
When you're taking over the lease, you'll have to get the consent of the landlord. So typically what happens is that the vendor will assign the lease to the purchaser. The vendor's landlord would want the vendor very often to remain responsible on the lease as a guarantor. You can either assign the lease or you can sublease the premises. But both the events, you'd have to get the consent of the landlord, and that becomes a major issue of going to the landlord, asking him if he will consent, payment of the fees of his lawyer, and you'd have to deal with the whole issue. So the purchase agreement very often is conditional upon the consent of the landlord. But that's one of the major considerations when you're buying the assets.
Okay, well, since we're talking about assets, I know you touched upon the Bulk Sales Act.
Yes.
Can you explain a little bit more in terms of what this act is and how it would impact the transaction?
The Bulk Sales Act of Ontario was designed to make sure that when the vendor sells the business, that he does not just take the money and basically, so to speak, run with it and leave the creditors of the business hanging and waiting for the money to be paid. To ensure that this does not happen, the Bulk Sales Act requires that the purchaser should obtain from the vendor a sworn statement of all the creditors. And you have to list them on a sworn statement, provide them to the purchaser. Purchaser should get it through the lawyer usually, and then the lawyer would register that document in the court as a record of the fact that there are no creditors that are claiming money from the vendor. If there are, you have to make arrangement for them to be paid off at the time of closing. So this is a mechanism created to ensure that the creditors of the business are protected at the time of sale of the business. It's a very small statute, but must be complied with each time that you sell the assets in bulk. It means not small items in a regular business, but when you sell the whole business, you have to make sure that you comply.
All right, well, we talked about the assets, but obviously businesses have their own account of inventory. How should inventory be dealt with in a transaction, and especially prior to closing?
In most cases, there will be an agreement that will specify that there is an inventory to be taken before the closing. And what typically happens based on the agreement made between the parties, that there will be an arrangement just prior to closing, very often the night before closing, for the parties to take the inventory. The inventory is taken, sometimes professionally, sometimes by an agreement, that the two persons, both the buyer and the seller, get together, see what is in the inventory, and there will be a clause normally to say that you'll pay an additional amount separately for the inventory, which is normally sold at cost to the buyer. So that the taking of the inventory the night before, the arrangement to transfer the inventory to the purchaser, taking a kind of a record of what is there on the day before closing, and paying for it are the key issues that you have to deal with when you're buying the business from the inventory point of view.
Right, so we talked about closing. Obviously, this is an important point in finalizing the transaction. So what exactly takes place on the day of closing?
So the two lawyers are exchanging documents with each other. In other words, just like a vendor and purchaser arrangement in real property, there is also in the case of the bulk sales sale, there is an exchange of the documentation, and the purchaser is making his searches, in particular the personal property security search, bankruptcy search, and a number of searches in which the buyer is trying to make sure, through the lawyer usually, that everything that is there is free and clear, including, for example, the retail sales tax, etc. So the parties are now ready for the date stipulated in the agreement for the closing, and on that particular day, the two lawyers are getting together or sending the documents to each other and saying that here are my documents as the vendor, and the purchaser is preparing his certified check and hands it over to the vendor, and the vendor hands over the documents to the buyer. So that essentially what happens on the date of closing. If there are liens on the property, then they would have to be dealt with on the date of closing, so that there is an arrangement for the payment of these parties, and they would have to provide a release or lifting of the lien upon payment, and that arrangement would be done by the vendor's lawyer by undertaking. So roughly it is an exchange of the documentation subject to the undertakings, and the parties do it either by courier or very often meet with each other and exchange the documents and exchange the check, and that's a closing.
Okay, so after the closing has taken place, and it having gone successfully, what are a lawyer's obligations post-closing, and how do some of the issues we talked about earlier, such as the Bulk Sales Act, assets, inventory, anything to do with allocating values, come into play for the lawyer's obligations following closing?
All those things, Roshan, that you mentioned would have to be reported, because there's an important part of the reporting process by the lawyer to his client, in which he would report all these issues that you mentioned, what happened in the creditors, what happened to the accounting, how much was paid, how was the Bulk Sales Act complied with, the fact of registration of the Bulk Sales affidavit, and what happened to the tax issue, and all other issues that were supposed to be dealt with are dealt with in the reporting letter to the client. If there are undertakings, they would have to be fulfilled after the date of closing in terms of what is to be done and what will be done. So that will be reported either after the undertakings or before, in which event the client would have to remember that these things are still unfinished and to be reported on after the undertakings have been fulfilled.
Okay, I think we talked a lot about a lot of the tangible aspects to the purchase of assets in what goes into the transaction. But I'm more curious in terms of if I was purchasing a business, it has a name. Perhaps this name has some value to it. How would I go about any intellectual property considerations that I should be mindful of?
So there are at least two types of arrangements that we'll have to deal with. One is the name that you would take over, and secondly there may be a trademark that you would have to take over. Trademark is a registered trademark and it will be assigned to the purchaser.
Okay, now if you had any advice to give to a client interested in purchasing a business, what would be the most important?
Well, I think you should deal with the lawyer and an accountant actually. And I think it's very important that the lawyer deal with it. As you can see, that these major issues that we dealt with are rather technical, and the tax aspects of it would have to be dealt with by the accountant, and so it's important to have a lawyer and accountant to help close the transaction.
All right, well, thank you for answering my questions, Mr. Chauhan.
Thank you, Roshni, and I hope you enjoy the program. My name is Jay Chauhan, and my website is jchauhan.com, and there are more videos you might like to watch, and they are under the YouTube and also on my website. Thank you.